This leads us to conclude that, under the best reading of the impeachment judgment clause, a former president may be criminally prosecuted in federal court without any requirement that he first be impeached and convicted for the same conduct. Reference 14 at the bottom of the page. Because we conclude that former President Trump is not entitled to categorical immunity from criminal liability for assertedly official acts, it is unnecessary to explore whether executive immunity, if it applied here, would encompass his expansive definition of official acts. Nevertheless, we observe that his position appears to conflict with our recent decision in Blasingame 87F 4th at 1. According to the former president, any actions he took in his role as president should be considered official, including all the conduct alleged in the indictment. Appellant's Brief 41, Tac 42. But in Blasingame, taking the plaintiff's allegations as true, we held that a president's actions constituting re-election campaign activity are not official and can form the basis for civil liability. 87F 4th at 17. In other words, if a president who is running for re-election acts as office seeker, not office holder, he is not immune even from civil suits. Id. At 4. Emphasis in original. Because the president has no official role in the certification of the electoral college vote, much of the misconduct alleged in the indictment reasonably can be viewed as that of an office seeker, including allegedly organizing alternative slates of electors and attempting to pressure the vice president and members of the Congress to accept those electors in the certification proceeding. It is thus doubtful that all 5 types of conduct alleged in the indictment constitute official acts. Appellant's Brief 42. 4. Double jeopardy principles. Former President Trump alternatively argues that the impeachment judgment clause and principles of double jeopardy bar his prosecution because he was impeached by the